Hi, everybody. Welcome, welcome, welcome. Thank you so much for being here this morning. Oh my gosh, there it is. Okay. My name is Louise Bush, and I run the Immigrant Post-Conviction Relief Program at the Seattle Clemency Project. And I want to thank you all so much for your interest in this project and for spending an hour and a half with us this morning talking about this really important subject and learning how to advocate on behalf of these wonderful people. I also want to thank Davis Wright Tremaine. Without Davis Wright Tremaine, we would not all be together this morning. They are working very hard with us to bring this project into the light. And I want to especially thank Kellyanne Brophy for her endless help in making this first training happen this morning. Okay, so Sarah, can we go to the next slide, please? Okay, let's talk about why we are together here today. Today is the first of 2 training sessions where we will learn how to advocate on behalf of individuals who are facing deportation based on old criminal convictions. We will advocate on behalf of these individuals by vacating their convictions in criminal court. So let me back up for a few minutes because I know that there are, and I see some of your names on my screen. And I also want to encourage you, if you want to turn on your cameras, we'd love to see you. We're doing things a little bit differently today than we did at our lunch and learn. We want this to be something where if you have something you want to say, you have a question to ask, please just raise your hand, have your camera on, put something in the chat, and we will all talk together because this is a training. But I do want to back up for just a moment because so we had a lunch and learn back earlier this summer about this very subject. And some of you who are here today were at that lunch and learn, and we thank you. And we are so excited to have you back. Thank you so much for being here. And we're really looking forward to working with you today and at our next training and moving forward. But for those of you who were not here at our lunch and learn, I thought I would just do a very quick summary for you new folks and probably a little recap for the people who were here over the summer. This project is a product of a partnership that 3 organizations put together. We are forming an infrastructure to take care of the individuals who are facing deportation. That partnership is comprised of the Seattle Clemency Project, the Washington Defender Association, and Northwest Immigrant Rights Project. And I'm going to very quickly talk about each of those 3. The first being Seattle Clemency Project. Very, very quickly, we were founded in 2016. And our mission was, and still is, but our singular mission at that time was to match volunteer lawyers with people who have life and long sentences in Washington state prisons, to match those individuals with volunteer lawyers to take them through the clemency process. And so that is seeking a commutation, early release from prison, in front of the Clemency and Pardons Board. And I want to say a little public service announcement. I can't help myself. Why did we need to do that in 2016? And why do we still need to do that? Because in Washington state, we do not have parole. A lot of people don't realize that. I know that an embarrassingly not that long ago, number of years ago, I didn't know that. We abolished parole in 1984. So when you get a life and long sentence in this state, that's it. There are new case law and legislative laws coming out now that do help with mass incarceration with life and long sentences. But in 2016, clemency was the only path forward. And still is a wonderful path forward for many people. So in 2018, we identified a new population of people to help at SCP, and it was also clemency based. And these were Again, individuals facing deportation because of old criminal convictions. We would match them with lawyers to take them in front of the Clemency and Pardons Board, not for a commutation, not for getting out of prison early, but for a pardon, because the conviction is the basis for the removal order. So if you can get that conviction pardoned, that removes effectively removes the conviction. And then the client's immigration lawyer, after we get the pardon, the client's immigration lawyer can take the client back into immigration court and seek to have the case reopened and the order of removal terminated. So what ended up coming from that is that we soon after 2018, we started taking pardons. We learned that there are certain convictions for which a pardon will not work to move an immigration judge to reopen the case and consider terminating the deportation order. For those certain convictions for which a pardon will not work, you have to go and the only other remedy is to vacate that underlying conviction. The only way to get rid of that conviction, if a pardon doesn't work, is to have that conviction vacated. So now we are getting together with all of you to train you how to do those vacates. Now, SCP has done a number of vacates to date, but we are really sort of cobbling them together. We are doing them without a really good process and infrastructure in place, the way we do have for our clemency cases. And why is that we haven't done this infrastructure yet? It's because it just requires a little bit more training, a little more hands-on than a pardon case or a clemency case. These vacates require knowing a little bit of law, which we are going to get into today, drafting pleadings, consulting with crimmigration experts, and there is at least one crimmigration expert with us here today, and appearing in court. And so that is why SCP partnered with Washington Defender Association and Northwest Immigrant Rights Project to form this process and infrastructure whereby we are going to be able to provide this service to these this deserving population of people. So I've already talked about Seattle Clemency Project, Washington Defender Association. What they so essentially bring to this partnership is that they train and they train you on the law that you will be citing in your vacate memos. They will train you on the law, explain the law to you that is the underpinning of these vacates. And they will also provide you with expert legal advice throughout your representation of your clients. I want to say it sounds like a lot. When I hear myself talking, I think, gosh, that sounds, it sounds complicated. It sounds like a lot, and it isn't. And what I'm here to tell you, and what I like to tell all of our trainees when we train at SCP, is we are here doing this training, and we are here for you the entire time because we know you can do it. It's not very complicated, and it seems complicated at first, but it isn't. You will not be sitting there going, what in the world am I doing? You will be sitting there going, okay, I remember this, I understand this completely. I know what I'm doing, and I have everybody here working with me toward this common goal. A Northwest Immigrant Rights Project, of course, are the immigration lawyers. They screen the client before the client ever gets to us. So they are the ones who screen the client and tell us, hey, this client needs a vacate. If you can get this client a vacate, then I can take them back into immigration court and seek to have their removal order terminated. Okay, so Sarah, the next slide, please. And I also want to mention that the amount of immigration law that you all need to know is virtually zero. And I will also add that that's approximately the amount of immigration law that I know. Okay, so introductions. I've already introduced myself. I am going to talk very briefly this morning about the problem. What is the problem? Conviction triggered deportations. Sometimes these convictions are decades old, and their impacts on local individuals in our community, their families, their communities, and the dearth, the near absence of advocates to help them. Let's see. Okay, so with Washington Defender Association is the only other partner who will be speaking live today. And we have today Sarah Hudson from Washington Defender Association. She is the expert in crimmigration, which is, as you could probably guess, the intersection of immigration law and criminal law. And she is going to tell you about the law that underlies the vacates that we will be seeking. I want to mention that Kevin Hollins is also here today. And Kevin is a lawyer with the Northwest Immigrant Rights Project, and he is the main attorney with whom we've built this partnership. He represents clients who are facing deportation. He does deportation defense, among other things, at Northwest Immigrant Rights Project. Okay, next slide. Okay, the problem, let's get into it. Let's see here. The problem is that we have individuals in our community who are at risk of imminent deportation and permanent exile from the United States. Permanent exile from the only home they've ever known, permanent exile from their families, their children, their jobs, their entire lives because of old criminal convictions. And again, usually these criminal convictions are quite old, 10, 20, and even 25 to 30 years old. The thing is, so often when we are talking about holes in the criminal legal system, we are talking about things that need to be solved, problems that need to be solved, and we're lobbying and we're just asking people to get on board with the fact that there's a problem. But the thing that's different about this project that we are all in on together here today is that reforms have already happened in this situation, which is that good laws already exist, that there is already an avenue of relief for these individuals, and that avenue of relief is seeking a vacate. But very, very few people in the legal community, and certainly very, very few people facing deportation for whom a vacate could help, know about this. And that's the really cool thing about this is that, and why do the reforms exist? Why does the good law exist? It exists largely because of WDA. Because of the work that Washington Defender Association lawyers have done over the years to put those laws on the books and to really strengthen them here in the state of Washington. But the problem is that not very many people are taking advantage of it. So our three organizations and all of you are building this together to start using these reforms, start bringing these reforms out of the dark and into the light, and start taking care of these people. Now, I'm going to talk a little bit about the people today, because, and I guess the last thing I want to say is, you know, if you have reforms and you have good law, but nobody takes advantage of them, they don't mean much. Reforms and good law are only meaningful if you have an infrastructure and a procedure to take people through. And that's what we're going to build with you all. Let's see. I'm going to show you two videos. I think maybe we should go to the next slide, Sarah. Okay, why don't we go, we'll keep that slide. We'll come back to that slide. I'm going to show two videos. The first is a video of a client of ours, Sarai. We got her a vacate just within SCP. We didn't go out to volunteer lawyers. She was literally sitting on a plane. If she wasn't days away from being deported to Cambodia, she was hours away from being deported to Cambodia and being forbidden from ever returning. And let's see this video of her, and she is very representative of the kinds of clients you all will be helping.
My parents fled Cambodia from the Khmer Rouge regime. They ended up in the refugee camp where they stayed for 10 years, and that's where I was born in 1989 when our family got the news that we were coming to America and resided in Aberdeen, Washington, where our family is. I was in a domestic violence relationship. He was really controlling, of course. You know, I had to drive him around because he didn't have a driver's license, and I just did everything that he asked. One day, he finally got caught selling drugs to undercover cop, and we both ended up getting arrested. I just found myself being processed into county jail, looking at 50 years in prison. It just felt so surreal because the whole time I'm thinking, like, what did I do? I didn't know until I was convicted was when my lawyer finally told me that, oh, there's a possibility that you are going to get deported and there might be an ICE hold on you. Living through that and trying to live a normal, productive life was really challenging. I constantly lived in fear, and I felt like I was traumatized from that fear of getting deported and separated from my kids and my family. The final incident with the guy that I was with for 10 years, he tried to kill me. You know, my son is screaming, witnessed the whole thing. He did 9 months, got released, and they didn't even recommend anger management or any rehabilitation classes except for drug and alcohol. And 2 months later, I get a letter from ICE that I need to be detained. They're going to go ahead and set me up with the interview with the Cambodian consulate where I will be deported. I just couldn't see a clear picture. All I saw was my life kept on going downhill. I just felt like I'm never going to get out of this situation because I've looked everywhere to try to help myself research how do I fix this issue, this legal part. And the whole time I'm thinking, like, I wish somebody know my situation and know, like, I'm really innocent, and I cannot believe that I was going through all of this, being kicked out of a country literally for something that I had no involvement in. I was sitting at IHOP with my 2-year-old boy, you know, like looking at him like, this is like the last time I'm gonna spend with my son. And as I'm going through my phone, you know, like just looking up lawyers, trying to find somebody to help me, I get a message from a lawyer through Facebook, told me that she wants to help me, and if I needed the help to give her a call, she left her number, and I called her right away. And she told me that she knew a Cambodian anti-deportation group who might have some resources that can help me in my situation. And to me, I'm like, wow, my luck is finally changing. For once, you know, like I felt like I have hope. That's where John from Seattle Clemency Project reached out to me. And he was the only lawyer who knew the legal part in my case. The only person that told me that they can save me was him. He told me that he can help me hopefully get my permanent residency back. And I've never had a lawyer been able to tell me that. And that was what I wanted, was to at least get that back. During that time, I already met with the Cambodian consulate, interviewed with them for them to issue me a travel document. And as I'm waiting in the detention center in Texas, Seattle Clemency Project went for a vacate. To my surprise, the prosecutor actually agreed to vacate my conviction. I had less than a week left before ICE was gonna put me on a plane, and I'm going. And to my surprise again, you know, I couldn't believe like everything was happening in my favor. The next day, you know, NERP didn't even hesitate. They filed the motion right away to terminate my deportation. And on Mother's Day, actually, was when I was released from ICE custody. Seattle Clemency Project gives people like me a second chance.
I'm so sorry, I was muted. Sarah, do you think you can go back to the slide about the clients? Thank you so much. Just kind of take that in for a moment. So I think she said this, but if she didn't, I mean, Sarai, obviously you can tell from looking at her, she's American in every single way, except that she doesn't have American citizenship because her parents didn't know when they came here after fleeing Cambodia and the horrors there. They didn't realize that they heard permanent legal residence, and what they heard was permanent, and they didn't understand that they needed to have her and themselves naturalized. She was born in a Thai refugee camp. She was about to be deported to Cambodia, a country she has never set foot in her life. So like Sarai, and we're going to show one more video in just a moment, most of your clients will be just like her. They will have lived here virtually all their lives. They've served their sentences, if any. Some of the convictions that your clients will have are relatively serious, and some of the convictions that your clients will have will be relatively minor. Even minor convictions can result in deportation orders. So if there was a sentence imposed, it has been served. Convictions are often decades old. Almost always the cases that we work on is from when the clients were juveniles. They have fully transformed their lives. Most have United States citizen spouses and children. Many, like Sarai and like the young man, well, he's not so young anymore, that you're about to see, San, are facing deportation to countries they have never set foot in. So if you think about it, it's nothing short of nuts is what it is. These are individuals who are they're just like everybody else. I mean, that's the only way I can say it. They're indispensable members of our community, just like our loved ones, and just like our loved ones see us, and just like we see our loved ones. They're indispensable members of our community: parents, spouses, children, siblings, aunts, uncles, employers, employees, leaders, mentors, coaches. I could go on and on. So please and you could see from her video that she didn't know where to turn. Let's see another video that will show now. Sarah will show it, and please be aware that it is difficult to hear. I would have loved to have the client come and speak with you today. He is very shy, and he agreed to go on camera. And we shot this in front of he owns an auto repair shop. And we spoke last week in front of his auto repair shop. So you'll have to listen kind of carefully. Okay, thank you so much, Sarah.
Hi, my name is Sun Crouch. Been in the United States since October of 83 or 84.
How old were you?
Maybe 6 months. Lived there ever since. I'm 39 years old. I do own this auto shop, going on 5 years strong. 4 kids, beautiful wife, married.
Have you ever been to Cambodia?
No.
You ever been to Asia? Do you know how your mom got here?
Basically fled, walked by foot.
Who else walked to the camps with her?
4 kids.
Where was your dad during this time?
I'm not sure. Yeah, I don't know. I think he died somewhere along the lines of it.
Do you know why your family was fleeing Cambodia?
During the war.
Pol Pot. What neighborhood did you grow up in Seattle?
In White Center. It's pretty rough in West Seattle. It's pretty hard. Single mom, foreign country with 5 kids.
Not a lot of money, obviously.
Right.
Did you go to school?
Yes. Made it all the way to the 7th grade and then kind of fell off there.
Got your GED later.
Right.
Yeah. You had been arrested, and what were you charged with?
Unlawful possession of a firearm?
Was it your gun?
No, it wasn't.
You didn't go to trial.
No, I didn't.
So you pled guilty.
Correct. So I had 2 kids at that time. Well, I was looking at possibility 16 years, I believe. So on the first day of trial, we set it up. Prosecutors came with a 24-month sentence. So we took it.
What made you want to take that 24-month plea?
Looking at my kids.
When did you find out that because of that conviction, you would be deported?
When I got to Shelton, when I got to the arraignment of prison, I found out that we have an immigration hold. That when I get released, I won't get released to home, I'll get released to immigration.
And then what went through your mind when you realized, my God?
Like, wow, we're going to get sent back after this.
And it's like, when you think about it, it's not sent back because you've never been there.
Correct.
Can you tell us how that made you and your wife feel?
Terrible. It's a feeling, I'm not sure how to explain it, but it's a terrible feeling.
What was it like living under this threat of deportation?
Basically, family, not seeing your family, your wife, your mother, being sent back to a country that you never set foot in, not knowing what you're going to do over there. Basically, worried about the family back here. So
And your kids knew about this?
yeah, my 2 older ones did.
And were they scared?
Yeah, they were pretty scared. We always hugged each other every time I went to check in immigration. They would always call me after that. I would get like so much missed calls. It took a certain time. Then every time I got out, I would call them. So.
What about your mom? What was it like for her, that worry? Do you know?
Oh, she was devastated. Man.
Having a child sent to a place that was so, that terrorized her.
Correct.
And you talked to lawyers. Did anybody ever tell you that getting your conviction vacated was a solution?
No. I had a lawyer for about 2 years before I met Seattle Clemency Project, and vacated was not one of the solutions for any case that we talked about.
Now that you've got the vacate, what's it like for your family?
Oh, it's pretty good now. I mean, everything is uphill from here. We got a fingerprinting on this Friday, so going for the citizenship. Don't have to worry, basically.
Okay. Let's put that slide back up, Sarah. So just like Sarai, San has lived here all his life. He served his sentence. The conviction is 20 years old. To say he's transformed his life, he got his GED. You know, he said he dropped out of school when he was in 7th grade, which is true, because, you know, a lot of refugees, both he and Sarai came as refugees from Cambodia in the very early 1980s. And they were settled into really economically impoverished areas, and they had very few resources. And so a lot of the kids did grow up and get in trouble. He dropped out of school in 7th grade, had his GED by the time he was 16, and actually went to college when he, even before he went to prison, and then more so after. He, like, as he said, he has a United States citizen spouse and 4 US citizen children. He has never been to Cambodia. And he is a son, a husband, a brother, a father, a business owner. He has 5 full-time employees that he provides full benefits for. He pays his taxes. And he was going to be deported to a country he'd never been to in his life for picking up a gun and shooting it into the air to stop a fight in 2001. So I use those two rather than just go on and on about the clients. That's great, Sarah. Thank you. I use those 2 videos just to show you these are the people we're talking about. They're our neighbors, they're our friends, and the situation is that there is a solution to help them, and people don't know about the solution. Lawyers don't know about the solution. So that's what we're here for today. And that's what we will be here for in our next training. Let's talk just one more second about the clients who are facing deportation. Here are some of the countries they have that our clients so far have faced deportation to: Cambodia, Vietnam, Laos, Cuba, Ethiopia, Mexico, Samoa, Philippines, and Brazil. Okay, I am almost all done. Let's go to my very last slide, where we're going to transfer over to the meat of this presentation, which is about the law. And this is my sort of the non-expert. Sarah is the expert. My non-expert introduction is to refer to Padilla v. Kentucky from 2010, which again, in my non-expert opinion, is sort of the change maker. In 2010, the United States Supreme Court held that if you are a defense counsel and your client has immigration consequences that could arise out of a guilty plea, you need to fully advise your client of what those immigration consequences are before they sign that plea. If you do not do that, your client has not been adequately advised, and therefore that conviction is open to being vacated as unconstitutional pursuant to Padilla. So as I said earlier, Washington Defender Association has been incredibly important in bringing Padilla into the state of Washington and making it even stronger here than it is in some other states. And so, Sarah, would you like to take it away from here and start telling us all about the law?
I can do that. Let me hold on while I transfer over and hopefully don't disconnect us all. I am running the tech today, and sometimes that goes better than others.
She's not just an expert at crimmigration, she's a tech expert.
So let us check and make sure that I can skip this. Okay, I think we are on our way. I will share with you. Okay, so this is all about getting your day in court again. And I apologize. I am actually going to try some interesting, weird, techie things with this presentation. So if they don't work, we can all laugh at the end and say that I am not really truly a techie person and I failed at that. But I figured since this was a smaller group, it'd be nice to get to know people a little bit, because hopefully we will be working together and you will probably be seeing a lot of me. And I'm sorry if that's going to be a problem, but I did want to get to know you guys a little bit. So I'm going to, first of all, put a link in the chat if you wanted to follow along with the slides as we have them now. I wanted to make sure that you could follow along if you like. There we go. So these are linked to the slides that we can follow along with. But before we get started, I want to try something that I have seen done with great success to kind of gauge where people are and kind of set a tone. So I'm going to try to pull the group. I'm going to drop a link in the chat, another one, and hopefully you can enter it. But if you can't, that's okay. It's pretty much a vote, and it's about essentially where your family came from. As we hear frequently, America is a nation of immigrants. And unless you were here before America was America, you probably are. And it'd be really interesting to find where people are from or where their families are from. And if you just came here and are now a U.S. citizen, or even if you're not, it'd be interesting to know where we're all from. And so I'm going to attempt to make this work. Voting should be live. You can enter up to 4 countries, and it will, in theory, pull and show us a map and words of where we're all from and where our families are from. So I will start. Let's see if it works. You never know. All right. And we will start to see things. I'm going to swap this out. We will start to see, hopefully, results populate if it doesn't crash my computer first. You never know. And we will hopefully, and if not, I can share my screen too. So that is the goal. And I can see there's some people here. So I would love to be able to put Jeopardy music in, but I'm not quite that technologically advanced. We're going to have to wait for the next one for that. So I am going to give it a couple seconds so that people can type and think. All right, so I guess we will start to see if answers populate or not. All right. All right, it is thinking. Hopefully. All right. Well, looks like I may have failed, but I will find them and I will share them at some point. But it appears I have failed at getting the view results. Maybe I have not. Always trying something new. Okay.
It was worth a try.
It always is worth a try. But let's see. I think it might have worked. Okay, here we go. So I will stop this and I will share this other screen. All right. So, okay. All right. Interesting places. Lots of places over in Europe. Very cool. So we can kind of, I hope you can see this.
Yeah, that's so cool.
So there we go. Awesome. All right. Well, now on to my less techy, more technical.
Sarah, can I
Yeah.
interrupt you? This is I hope this is the last time I'm gonna interrupt. I did want to say, I don't know if any of you all were born not in the United States. I do want to say that I was not, but my parents had the wherewithal to do the paperwork, I guess, when I got here, so that if I committed a crime, I would have done my time and then been released to my home. I came when I was 3, so I was much, much older than many of our clients were when they came to this country. So it's arbitrary. If your parents had the wherewithal to get the papers signed, that's great. If they didn't, which is the case when you're traumatized and fleeing a war-torn country, it doesn't turn out very well for you. Okay, sorry, thank you.
No, no problem. And so today we are just going to go over pretty much the law of PCR. I'm not going to go super in depth because I could really bore you to death and totally nerd out on some of this stuff, but that's not essentially what I'm going to do today. We're going to go over the brief history of immigration. I've gone over this before, so I'm going to go over it briefly again, but not in too much detail. It is not meant to be exhaustive. There's way too much to even cover in 45 minutes. I'm going to go over the immigration specific law and also some of the federal case law that we use that underpins why this becomes possible. And I'm also going to give you an overview of the vacate process, how the law we discussed fits into the process now. So I've included links on this PowerPoint, and it should be available in your PDF as well for you to explore different videos and different things about immigration laws or immigration itself in the United States. Some of them are really interesting. Some of them are very informative if you've never studied the subject. But there are video explainers, so that way you can do it maybe in the background, maybe in a couple minutes, not very long. But there are a few things about this history that I am going to highlight. However, first I'm going to show you a timeline. I created this timeline just for you guys. So this is our version, and I put a URL at the bottom, so maybe you can see it bigger. I don't think it's probably very big on the screen, but just a timeline so that you can see where things fall in. And essentially the takeaway from this is that not much really has changed. We have, in 1790, we have immigration laws that start, and we really still tightly control immigration. In fact, it may have actually gotten worse. And we talk about these newer laws, and by newer, I say 1996, that is pretty much still governing the process now. And we also have criminal laws from 1996 that are still governing the process now, and really not much has changed. All right, there are 2 cases I want to highlight, or 2 things in history that I particularly want to highlight. One of them is Gideon versus Wainwright. Now, I don't know how many of you have heard of this case. Maybe you have, maybe you haven't. But in 1963, Gideon versus Wainwright was decided by the U.S. Supreme Court. This case paved the way for the public defense system as we know it today. Mr. Gideon was charged with a felony in Florida. He asked to be appointed counsel. They denied his request. He represented himself at trial, but was ultimately convicted and sentenced to 5 years in prison. He filed a habeas petition, but the state court denied all relief. The Supreme Court appointed counsel and took up the case. The court decided that the Sixth Amendment provides that the accused shall enjoy the right to have the assistance of counsel for his defense in all criminal prosecutions. That provision was made applicable to the state by the 14th Amendment. Essentially, a fair trial cannot be assured without provided counsel. However, I do want to highlight that that is not the case in immigration proceedings. People like Kevin and people at NERP are pretty much doing this work as a nonprofit, but they are not appointed. People are not entitled to their help. And there are probably more people, Kevin probably knows this better than anyone, who need help that they can't help because there are just too many clients and not enough lawyers. And there is no system in place for helping these people in immigration court. So many people go in unrepresented. Many times the first time they hear about these problems with their immigration case or their criminal cases is when they're in court or when they're getting orders for deportation. And by then, they don't have the skills to argue why this shouldn't be the case. They need people like Kevin to be there for them to argue this to the fullest, and they're not entitled to that. And so it becomes a very difficult problem when you have people who don't know what they need to do and aren't appointed someone who does. And so, although the public defense system in the US is not perfect, it is certainly far from perfect and is indifferent in every state, there at least is something for people. Whereas in the immigration system, there isn't. I did include an explainer video link in case you're interested in the nitty-gritty of Gideon. The next set of laws that I want to get into were both put forward in 1996. The Anti-Terrorism and Effective Death Penalty Act was a sweeping law passed in 1996. The most notable changes were made to the law of habeas corpus. It not only included a statute of limitations and restrictions on successive petitions, but it narrowed the grounds on which a successful petition can be made. It eliminated judicial review for some deportation orders, so it had a huge effect on immigration. Added mandatory detention in some cases, removed discretion in aggravated felony cases, and criminalized illegal entry and re-entry. It essentially changed the landscape for both criminal law and to some degree, immigration law. Now, I'm going to pause here and let YouTube explain IRA. Now, this is the Illegal Immigration Reform and Immigration Responsibility Act. And this video is, well, interesting, but also has a perspective, like many of us. I'm going to stop this, and I am going to play for you this particular video that I had to download from YouTube. So we'll see, again, me and my text, we'll see if it works.
When Americans turned on their TVs in the early 1990s, one contentious issue was hard to miss: immigration.
Is immigration good for America?
The federal government won't stop them at the border.
You spend $5.5 billion a year to support them.
There's a right way and there's a wrong way.
At the time, there were around 5 million undocumented immigrants in the U.S. And most Americans saw immigrants as a burden on the country, taking jobs, housing, and healthcare, and thought immigration as a whole should be decreased.
Our country is invaded by immigrants who are like cancer cells.
That same year, Republicans ran on a tough on immigration platform and took control of Congress. Democrats were pushed to adopt tough positions on immigration, too.
We are a nation of immigrants, but we are also a nation of laws.
In 1996, President Bill Clinton signed a major piece of legislation, the Illegal Immigration Reform and Immigrant Responsibility Act, or IRA. Its goal was to decrease the number of undocumented immigrants. It did the opposite. Before the 1990s, undocumented immigration into the U.S. looked very different. For one, it was usually temporary.
People used to go back and forth across the border. They would go north and, for the harvest, and they would earn some money and they would go back to Mexico.
And if they wanted to come live permanently in the US, there were a few legal channels, but not many. If they married an American citizen, they could get lawful status. Or if maybe their brother was a citizen already, he could sponsor them. Or an employer could. And these could be done after they were already living in the US undocumented. Before 1996, the threat of deportation was relatively low. People were commonly deported for committing a crime, and it was mostly limited to major crimes like murder or trafficking. But IRA, together with other 1996 laws, drastically expanded deportable crimes to even minor infractions like shoplifting. It was also retroactive. So say it's 1976 and someone is caught stealing some albums from the mall. They wouldn't be deported. Over the next 20 years, they never commit another crime. But after 1996, they could be deported because of that old misdemeanor. And not just if they were currently undocumented. This applied to immigrants with lawful status too. And previously, an immigration judge could decide if the deportation should even take place. Now things were a little more automatic.
Ignoring the fact that those deportations would be extremely harmful to U.S. citizen children or to spouses.
Deportations skyrocketed, and IRA created the framework for future laws that further expanded reasons people could be deported, especially after 9/11. But IRA also made another huge fundamental change in the U.S. immigration system.
One of the aspects of the 1996 law that is particularly strict and I think in many respects inhumane is the so-called 3 and 10 year bars.
Those 3 and 10 year bars made these legal pathways nearly impossible to obtain. They work like this. Anyone who's been undocumented in the US for 6 months and wants to gain legal status first has to leave the country and be barred from returning for 3 years. If they've been undocumented for more than a year, they're barred for 10 years. So if they want to get lawful status through a job, they first have to leave the US for 10 years. Or through their brother, leave for 10 years. Or through their spouse, leave for 10 years.
It's family separation by another name. The bars were intended to try to essentially create punishments that were so severe to deter people essentially from coming here. But as we've seen with many other deterrence-based policies, the practical effect is very different.
Instead, it incentivized people to stay in the U.S. undocumented. Before IRA, Mexican immigrants who came to the U.S. unlawfully were about 50% likely to return to Mexico within a year. But after 1996, more people started staying in the U.S. There were around 5 million undocumented immigrants living at the U.S. before IRA. Today, it's at least double that.
And we are somehow surprised by this outcome. This is of our own doing.
Laws like IRA shaped the way the U.S. focuses on immigration enforcement as a deterrent. But really, it proved that stronger enforcement doesn't actually stop undocumented immigration.
These laws or the politics of the 90s didn't really change the reasons why people come to the United States.
Today, views on immigrants are very different than they were in the 1990s. Most Americans now see them as a strength, not a burden. But the laws created here haven't changed.
Requirements and standards that were created decades ago that aren't responsive to our needs as a nation, they certainly aren't responsive to the needs of immigrant populations.
The idea that if we only had more guns, if we only built a higher wall, that we'd solve all the problems, I think we learned from 96 that's not the way it works. It's not that simple.
Thank you for bearing with me. I will not stamp that all of that is accurate because nothing on YouTube ever entirely is. However, it is a pretty good explanation about how that works. It's a pretty complex set of laws with lots of different facets, but it absolutely can have those sorts of devastating effects. So here I go again with my fancy text. We're going to try it one more time, see if it works. So this is same one. It should be a different slide. What it is going to ask you about is any of the immigration or federal cases that kind of support these sorts of processes. You don't have to know, you weren't expected to study, come with any knowledge, but it does help me to figure out where I need to gear things, if at all. I can do all of it, but some people might prefer more in depth about one thing or another, or I can give an overview either way. So there's one person here who I at least know would be cheating, and that would be Kevin. So I know Kevin will know all of these because Kevin is the immigration attorney here. But
we'll see, I hope.
No, we'll see. I think you know them all. All right. And I will do the same thing I did before. And once I see that some people are here and we've given it a second, I will share my screen again because clearly my method did not.
If it's okay, I think I might also just add, first of all, I absolutely loved that video and had never seen it before. And it was quite genius. But I do want to also add that to date, all of the clients that we have worked with have been documented. They have all come to the country legally and have been living here for many, 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 many years, if not their whole lives. And it was the conviction that stripped them of their legal status, but they were here. They were not undocumented immigrants to begin with.
Okay, I think I've gotten to some degree what I'm gonna get. And so I will share the results just because it can be interesting to see. So we have a lot of Padilla, awesome. Also, more than I expected for Strickland. Good, PCR, rock on. Okay, so now I'm gonna stop this nonsense that I am now creating and we'll move back to the underlying law. So let's get into it.
And Sarah, maybe just, I'm not sure if you said what PCR is, but maybe
I can do that. Post-conviction relief, that's the abbreviation I use for it. You will probably hear me use a lot of abbreviations. Stop me if like Louise does and give me a reality check when I start doing alphabet soup for you. So Strickland versus Washington. Although not an immigration specific case, it is the foundation on which we build these ineffective assistance of counsel claims. This case recognized that effective assistance of counsel was required and determined the benchmark for judging any claim of ineffectiveness must be whether counsel's conduct so undermined the proper functioning of the adversarial process that the trial cannot be relied on as having produced a just result. They established a two-pronged test. First, whether counsel's performance was deficient and whether the client was prejudiced by the deficient performance. Now, interestingly enough, this case has been used in other contexts. It actually has been argued in other immigration cases as that it shouldn't apply. Guilty pleas shouldn't be included because they were talking about a just trial. It was a very interesting set of cases where the prosecution or the government argued that it only applied to trials and therefore shouldn't apply to any other thing. The court was pretty quick to smack that down, but to be fair, they tried, and they probably, and they do sometimes try in your cases to make these same arguments that have been tried before and shut down. So be aware that those are floating around. Next, the one that most people seem familiar with, Padilla versus Kentucky. This was in 2010. It is an immigration-specific case that holds that deportation is a penalty, not a collateral consequence. For years, the court had considered deportation or immigration consequences as collateral consequences and not a penalty. However, this case changed all of that. A legal permanent resident, otherwise known as an LPR, pleads guilty to drug distribution charges and then faces an unforeseen deportation, both to the client and the attorney who was representing them. The court said that the Sixth Amendment requires that immigration consequences be addressed with the client because deportation was a priority or was a penalty. The duties they talk about are to give affirmative, accurate advice regarding a guilty plea, conviction, or other resolution. Failure to advise can be ineffective assistance, and they say that the Strickland test is the one that they are using to determine IAC. They essentially say that because this is just a garden variety 1-2 IAC claim, Strickland is the case to use, especially since they've determined that the Sixth Amendment right to counsel attaches. It is important to note here that although the court imposed a duty on defense attorneys, they did not create a mechanism to ensure that people were getting the requisite advice. I can tell you this, I was a public defender for years, although a little bit different than some of the other ones because I had been an immigration attorney previously, but I was most recently a public defender. There are no mechanisms. There is no support. Washington is so lucky to have the Immigration Project. I worked with them before I was part of the organization. They are the people who can advise, but many states don't have that. Many states don't have anyone who is advising in a way that people can be getting reliable advice. They are left with a piecemeal system and kind of left to fend for themselves. And that is truly tragic for the clients involved because how could they possibly know what is going to happen? And the attorneys aren't experts in immigration law, nor were they ever supposed to be experts in immigration law. And so I say this because you will likely interact with defense attorneys on these cases who were doing everything they could. They have competing demands on their time. They have competing demands on their resources. However, lots of times they just didn't have the tools necessary. And so that is why many of them are willing to fall on their sword and say, yeah, I didn't do that because I didn't know I had to. I didn't have the resources. And so I really wanted to take a second and center that in this presentation because this isn't really about them. This is about the duties that the Supreme Court imposed and then never gave anyone support, never gave anyone any mechanism. And there was never a roadmap provided on how criminal defense attorneys were supposed to become experts in immigration law. After that, things changed, at least for some people. In 2012, we had Lafler versus Cooper, holding that the Sixth Amendment right to competent counsel extends to the plea bargain context, as it is a critical stage of the criminal proceeding. Mr. Cooper claimed his attorney had provided ineffective assistance of counsel when they had advised him to reject a plea deal in a case citing that he could not be convicted at trial. He instead was convicted and received a penalty that was at a minimum 3.5 times greater than what was recommended under the plea agreement. It was certainly tragic for Mr. Cooper, and he went back and said, I never would have pled guilty. I never would have gone to trial if I knew that I could be convicted. I had been told I wasn't. They again applied the Strickland test, which they apply in so many cases, and said that absolutely it does apply, and ineffective assistance of counsel is an option if you are misadvised into pleading or to going to trial when you didn't necessarily have to. All right, now Washington, and more recent, a little bit. In 2011, Washington takes the baton from Padilla and applies it to our case. Here, there was ineffective assistance in the plea process when Mr. Sandoval was offered a reduced charge, and the attorney advised him to take the offer because he wouldn't be immediately deported and would be able to get advice about any potential immigration consequences after he had already fled. The court held that defense counsel's mitigation advice may not be couched with so much certainty that it negates the effect of the warnings required under Padilla. The court addresses the prejudice prong of the Strickland test, saying that they think given all Mr. Sandoval was losing, he would have been rational to take his chances at trial. Therefore, these circumstances satisfied the ineffective assistance of counsel test and necessitated a vacation of the conviction. Next, Washington State takes up Sy. In re Sy is a personal restraint petition case, so otherwise known as a PRP. The court applies the Strickland test, but in doing so, makes Padilla retroactively applied to Washington. There is a fact-specific inquiry into the reasonableness of the attorney's actions that is measured against the applicable prevailing professional norms. They also create an exception to the one-year time bar in RCW 107390, stating that in light of the legislature's longstanding commitment to ensuring non-citizen defendants understand the immigration consequences of conviction, and this court's longstanding commitment to ensuring criminal defendants receive effective assistance of counsel, such an outcome would be unjust and falls short of the values underpinning our state statutory framework. Washington is only one of a handful of states where Padilla is retroactive. I have worked in places where Padilla was not retroactive, and this advice and this remedy wasn't available to people. This particular case makes it possible to go back in time and right those wrongs. Many places don't have that. Some are working on mechanisms that allow them to do that. But this case really set the tone for what we are allowed to do now and how we move forward, and how people like Kevin can ask to have these convictions vacated so many years later and then take them back to the immigration court. Last but not least is the 2017 Supreme Court case of Lee versus the United States. The court dives deeper into what must be shown in criminal cases with immigration consequences and applies the Sixth Amendment yet again to the entering of a guilty plea. This case is particularly interesting because it is more recent. We aren't talking about precedent that was from 10 years ago. We're now talking about precedent that they are now reaffirming their commitment to Padilla and reaffirming their commitment to applying the Sixth Amendment right to effective assistance of counsel to these particular types of proceedings. This is huge because the court has changed and the court is still changing. And so we will need to watch that going forward to see what happens in the near future on some of these cases, as things tend to change when you have the shadow docket. And so things have certainly happened and will continue to happen that affect some of these rights. But that's what I'm here for. I'm the one who has to watch this for you and make sure that things don't change. Okay, now on to what you actually wanted to know about and had to sit through me talking about the law for, vacate. Now, I even wrote in this presentation because I am not going to go over it in depth. It is way too much to contemplate here. There are too many avenues, variations. That is something I'm going to leave for Louise. Yay, or Louise to do next time. Yes.
Yes. So next time, our next training will be lengthier, and it will be literally a step-by-step, very detailed step-by-step walk through how to do a vacate. So do not worry about a thing. What today is learning about the law behind vacates, and next time we will be giving you a vacate manual, all of the sample pleadings, sample letters to the prosecutor, everything you will need. And, first you do this, you interview the client. Next you do that, you talk to the defense attorney, and just go through the whole thing. It'll all be spelled out for you.
We always want to make sure to reassure people of that, because I know that sometimes it can come at you pretty quick. And
yeah.
So,
It's all going to be very, very easy to understand. Trust me on this.
So now that we've had the basics of the cases that we typically use, we can start to see how it all fits together. So we, as a team, look at the immigration consequences at the time, as well as currently, to determine the prejudice to the client. If there wasn't any prejudice, you wouldn't be able to assert prejudice under the Strickland test. So, but if there were adverse consequences, then the client should have been advised. And if they weren't, then Padilla, Sandoval, and Strickland allow us to show that that client was prejudiced. By looking at the consequences now, we're able to tell the court what immigration safe charges can be pled to safely that do not jeopardize their status in the same way. If we're unable to find a safe haven, is what we call these immigration safe charges. If we're unable to find them, then maybe they didn't exist then either, and maybe the client wasn't prejudiced. So it's this analysis of how all of these things fit together and what we have to tell the court and what we have to represent to the court to make sure that we are actually hitting all of these Strickland prompts. Because there, by all means, is pushback from prosecutors who don't necessarily want to do this. However, lots of them do, and when presented with the right information, they absolutely will agree. But as a public defender, I was a litigator, I litigate. I'm used to litigating everything, so I'm always backstopping every single thing. Because if we do have to litigate it, we want to be ready. Now, SCI helps us in Washington by giving us an exception to the time bar and allows us to file for relief well after the normal timeline is run. This is how we get back into court. SCI gives us the very mechanism that we need to say, hey, we don't need to fall by this 1 year time thing. Because when you go into immigration court with someone like Kevin, maybe by yourself, you realize that this could be 10 years later. You may not have had a date, or they may have just discovered there's a problem and then they can file. And you're going, well, now this is 10 years past when I've even finished serving my sentence and any of my consequences. And now I need to get back into court. SCI makes that possible. SCI makes it possible for us to say, hey, this is not something that should be left open. There's an exception to the time bar for exactly that reason, and we can get back into court. Now, there are two vehicles that we usually use to get in to vacate these sorts of convictions. A 7.8 motion and a PRP, personal restraint petition. I won't go into more details about this than to say that the 7.8 keeps the case in a local jurisdiction, and the PRP moves the case out of the initial court and to a higher level. A PRP can take a much longer time, and strategically that might be what you want to do. A 7.8 typically takes less time and involves more discretion from a local jurisdiction or a local prosecutor, and typically moves more quickly. That is up to people like Kevin to tell us how much time we need to take or if we need it tomorrow. So we work with them. We will get instructions and marching orders from people like Kevin. Once you decide which will be best for your client, you file the appropriate motion, and then we all start ramping up, whether or not it's agreed. If it's not, we prep you for that too. So that is where we go from here. My last slide is just contact information for my team. Not my team, our team. They're not mine, trust me. They've been at this way longer than I have. So this is our contact information. My email address is here. Louise knows how to get in touch with me. Kevin certainly knows how to get in touch with me. And if you have questions you don't want to ask here, that's perfectly okay. You can email me. I answer my email pretty quickly. Louise, you're unmuted.
I did unmute. Well, whenever you're ready, I thought
I am ready. I left plenty of time for questions because I expect people to maybe wonder about things.
Yeah, I just wanted to, first of all, thank you very, very much, Sarah. So I just wanted to sort of go back and reiterate what I was saying earlier. When you hear a lot of law like that, and you hear about, 7.8 motions and things like that, it can be overwhelming, and you think, well, how am I gonna know what to do and go back into court? And please believe me that we have been doing these for a while, and we know exactly the steps that you're going to take. We're going to give you examples on every single motion you're going to file. And what Sarah was talking about is when you have to litigate a case. So far, we have not had to. I'm not saying you won't have to, but we have not had to yet. What you do is, and this will all be what we're going to talk about in the next training, you meet with your client and interview your client, get to know your client, determine that your client, in fact, was not adequately advised of the immigration consequences of the plea, and you draft a big letter that talks about that just states that they were not advised, and this is the law that says that they needed to be advised, and then talking about the threat of deportation and talking about the equities that client has. And you send that to the prosecutor and open up a dialogue where you are negotiating with the prosecutor to agree on a motion to vacate pursuant to Padilla and the Washington laws that Sarah talked about, and to either just vacate that conviction outright because it was unconstitutional because of the lack of advice, or if not to vacate it outright, to vacate it and then replead, as Sarah said, to something that is immigration safe. And you will be working with Sarah the whole time to determine which kinds, like what can you replead to that will be safe for your client. So like I said, we've done a few of these at SCP so far. And what we're doing is sort of eliminating the middleman, where what we would need to do in the past was we were reaching out to the NERP lawyer for our client. So whether it would be Kevin or Henry or Bill or whoever the lawyer was, and then the NERP lawyer would sometimes be reaching out to the Immigration Project at Washington Defender Association to say, is this a safe replead? And then come back to us. So now we're all working in concert with one another to make sure that we understand what a safe replead is. So I can't reiterate enough that, this background information that Sarah provided us with, particularly that historical information, we just thought was really important for you all to have today. But when it comes to the next training, you'll see from the handouts from the sample pleadings that we give you that the law is largely the same each time. The client was not advised that these are the laws that say that it needed to be, and it will all make sense. Let's see. Oh, and by the way, at the next training, there will be someone with us, Neil Fox, I think, who has litigated a number of these kinds of vacates where things did kind of not work out the way we wanted, where the prosecutor just agreed and said, sure. And again, that's what's always happened in our cases so far. There will be times probably in smaller counties, not counties that are on the I-5 corridor, where prosecutors don't want to agree to vacate, and then it needs to be litigated, and Neil will help us through that. As Annie Benson, who was Sarah's predecessor at WDA, used to say, and I'm sure all of you already know about this already, justice by geography. So if you're in King County, I think the way we sort of look at it, most of us here would probably agree you get a little more justice there than you do sometimes in some of the other counties on the other side of the mountains. So let's see, does anybody have any questions? We're at about 10 minutes to 11. Or if Kevin, if you had anything you wanted to add, if anyone has any questions.
Yeah. Before we jump into questions, I'm just going to read aloud the CLE code for today.
Thank you.
So I'm going to put the link to the CLE form in the chat. So if you haven't had a chance to fill it out, you will need to enter this code in order to receive CLE credit for today. And the code is 816271. Again, it's 816271. And that's all I have.
Thank you, Kellyanne. Yeah, it looked like Francesca, did you have a question?
I had a question because it seemed like a part of the presentation you were talking about the side case and how it made Padilla retroactive in Washington. So I was kind of wondering if you then just work mostly with people who have Washington criminal convictions as opposed to federal criminal convictions, and if people do have federal criminal convictions that are before 2010, how you kind of deal with them.
We thank you so much for that excellent question. We do only work with state convictions. We're not working with federal convictions at this time. And on the retroactivity, I mean, just picture, when Padilla happened in 2010, word went out. Oh, wow. And just like Sarah said, this is not the fault of individual, public defenders or criminal defense attorneys. Like, the last thing in the world we're trying to do is put the blame on them. It's the system. They did not know they needed to advise. So in 2010, they started realizing, oh, okay, Padilla. So now we need to advise. We need to find out if someone, you can see how if Sarai or San and some of your clients walk into the room with their, Seahawk hat on, you don't even think to ask, are you a US citizen? I mean, you need to ask that now, but prior to 2010, that advice wasn't being, routinely given. So when they started giving that advice, that makes, vacates more difficult to get, because were you advised? Well, yes, I was. So having it retroactive in Washington just makes it so that if you have somebody with a conviction from like 1999 or 2001, you think to yourself, there's every chance in the world that this person didn't get the proper advice. And that's why it's so incredible to be in a state like Washington where it is retroactive. And so we have to imagine that there are legions of people with these old convictions who do not realize that they can avoid deportation by having their conviction vacated, or at least attempting to do so. Anybody else? Any words of wisdom, Kevin, or?
I'll just say thanks for, considering doing the work. I mean, it's really important to us and to our clients. Like as was mentioned before, NERP, we're an organization of about 100 people, but we still only fully represent probably 10% or so of the people who come through the detention center in Tacoma. And we, considering all the people who are in removal proceedings in the state, I mean, we can only represent a small fraction of them. So really any resources that can go towards immigration law is huge. And I hope you got some sense for sort of what the immigration system is like, even though you won't need to be expert in it. I think understanding kind of how messy and arbitrary it is important, because most people are kind of navigating that system by themselves. And in the context of criminal convictions, it's even more messy and arbitrary, because whether or not someone will ultimately be deported for a conviction depends on what state they were in when they were convicted of the offense, who the prosecutor was, who the judge was, who their attorney was, whether any of those people were conscientious of immigration consequences. And then it depends on all kinds of other factors in the immigration system. And, do they end up getting identified by ICE for any reason? Which immigration judge do they end up in front of? All those factors. So there's so much arbitrariness to the system. So really, you can help us all restore a little bit of fairness to it by doing this work. So thanks for doing that. And the law is in our favor right now, and that's not guaranteed to be the case forever. So let's do it while we can.
Perfect. That's exactly right. And another thing, as Kevin is saying, that, NERP can only represent, and we get 95% of our cases from NERP, but we also do get referrals from people we've already helped. They have friends, they have co-defendants. So we end up, getting people from NERP, but also from other avenues. But when we build this together, our three organizations, with the help of Davis Wright and you volunteer lawyers, we're going to build this together. We start getting vacates for people, and then people start hearing about it. And that's how the news spreads that this law is available. So like San said, he had an immigration lawyer. Sarai was out looking for a lawyer. People just didn't know. It's just not used. So we're putting this together where we can start doing these, and the more we do them, the more people we'll be able to help. So we're all in this together. Welcome to the family. I do think if no one else has a raised hand, we can let you out 5 minutes early. I do not know when the next training is, and I will be talking to Kellyanne and Davis about that. I have a pipe dream that it would be in person, but we will see. It's much more involved. It's going to be fun. It's going to be interactive. It's going to be nuts and bolts. And I'm already looking forward to it, but I can't announce when it's going to be because I don't know. So pandemic times are still with us. So let's see what happens. And thank you, Sarah. Thank you, Kevin. Thank you, Kellyanne, Davis Wright, and thank you so much to all of you for coming this morning. I can only imagine you now have a lot to do with the rest of your day. So thank you.